Hello, good afternoon, dear students. Now, before I resume my lecture, I have certain points to clarify. First is that in case any doubt is there to any student or any query is there with regard to any topic, you please send that through Instagram, but mention name of the teacher. That is, in my case, you can refer just Grewal. Or alternatively, you can send that by WhatsApp also. You can find out my number, WhatsApp number from the institute, or alternatively, I'll also tell to all of you, and my WhatsApp number is 98 156 00 157. Sorry, it is wrong. I'll tell it later on. Okay, now we start with that. The two queries I have noticed from the earlier lecture. One was relating to the point that some of the students have mentioned that offences are under the IPC, not under CRPC. Perhaps they could not properly follow what I have said. I have not told that offences are under CRPC. When I was explaining illegal omission, it was in that context that as per section 43, three situations are given which make it omission illegal. First in that case is if such omission is designated as an offence. Now in that context I refer to Criminal Procedure Code. If you look at section 39, section 40 of Criminal Procedure Code, it provides that certain village officers must inform to the state authorities the commission of certain offences within their village. How to force that? That can be forced only when some sanction is there, and that sanction is provided in IPC. Section 175, 176 makes it a punishable offence if they do not inform. So I have not told that CRPC is creating. CRPC is providing for a pattern of behavior which is required from village officials. To force that, a kind of a sanction is there by making it an offence. So section 175, 176 of IPC makes it an offence if they do not disclose that. Thus, offence is under IPC, not under CRPC, because every law, whether it is a civil law or it is a criminal law, provides for a pattern of behavior which is expected from the person to whom that law is addressed. If they conform to that, it is okay. If they violate that pattern of behavior, in case that violation is made punishable offence, then it falls in penal law area. Then CRPC will be dealing how to deal with that situation. If it doesn't provide punishment for that violation, then it falls within the area of Civil Procedure Code. Then CPC, Evidence Act, shall be followed to decide that, and whatever legal proceedings in that situation are required to be followed. But in case of criminal law, the procedure is to be followed under CRPC. in case of any violation of that pattern of behavior which requires a person to act in a particular manner. If he doesn't act in that, then in that case he can be subjected to punishment. Now, the second query was relating to illegal omission. Because omission itself is not an act of serious unless it is illegal. Now, three categories of situations are mentioned which make omission an illegal omission. First category is if it is made an offense. If it is made punishable, as it is there in case of section 175, 176 of IPC. Because non-disclosure by a village official of certain offences has been made an offence. So in that case, you will have to point out the law, the section which makes it an offence. Then that omission is illegal. Second category was that if that act is prohibited by law. And the third category was that if that provides grounds for civil action. So for the first and the third category is concerned, many examples can be there to clarify that. The query was relating only to the second point, that what are the acts which are prohibited and are made illegal. The answer to that is an act is prohibited again under the law. So there has to be some provision of law prohibiting the doing of any act. Moral prohibition will not be taken account of. Only legal prohibition has to be taken, and for that there has to be some kind of a law prohibiting that kind of a conduct. And the example to justify or to just make it clear are that most of the cases it is omissions which are relating to possession. I'll give example. Suppose you are given some property by some person. In fact, it is a stolen property. You are not aware of that. You paid the full price for that. And that way you are innocent. So possession of that is not offense. Because there is no dishonest intention on your part. But suppose later on you come to know that it is in fact a stolen property which you have purchased or which has been passed on to you. Now you continue to retain that. You don't disclose that. That possession becomes illegal. That omission on your part not to disclose to the police or not to make efforts to undermine dishonest intention, that will make that possession illegal. That will be illegal omission on your part if you do not disclose that, if you continue to retain. You have not done any act. You are just silent. You know that it is stolen, but you don't talk about that to anybody. You don't tell the police. You don't inform anybody else by which you can prove that your intention was not dishonest. Now here your possession become illegal possession because you have violated that, and by not disclosing that your possession becomes illegal possession. Take another example. Suppose you have acquired some material which in fact is narcotics. Take it that it is opium. You are not aware of that. So you are possessing that. Now here mere possession of that is offense. Prohibition is there. Act is prohibited that if you are possessing any narcotic material, it is prohibited. So that again is illegal omission on your part to keep it. One of the questions that may arise, that how does he know that it is a narcotic, it is opium? Answer to that is very simple. Everybody is presumed to know the law. Ignorance of law is no excuse. Thus, if he is found in possession of opium, whether he is aware of that or not, he is liable for possession of narcotic material. So these are two examples where the person doesn't do anything, but he doesn't disclose that. That will make it a punishable offense, because that omission, that non-disclosure will be illegal and accordingly treated as an offense. That can be there under other laws also. If any person is required to disclose certain things, he doesn't disclose that, and that is taken to be an offense, then it too will fall within the category of illegal omission. Secondly, the term illegal defined in section 43 is not meant only for possession. It's not meant only for second category, that is illegal omission. It is a general definition which is used for other sections also. You can find in many sections the term used illegal. So it is not exclusively meant to explain the term illegal omission. But in all the three cases, one thing is very clear: whether it is the act, whether it is illegal omission, whether it is furnishing grounds for civil action, some kind of a duty is imposed upon a person, and in defiance to that duty, he doesn't act accordingly, then in that case, that omission shall be treated to be illegal omission for the purpose of penal liability. So these were the two queries which were there, which I have tried to explain. If still some doubt is there to anybody, he can again ask the question through Instagram or by WhatsApp also. I'll be able to answer next lecture as and when the next lecture takes place. So with these two queries over, now I resume the lecture which I had left last time, just to make a summary of what we have talked about earlier. Earlier I had told that two fundamental requirements for penal liability are to be there. One is some actus reus must be attributed to the accused, and actus reus includes illegal omissions also. If you look at section 32, it is not defining act. It is only inclusive in nature. It says that omission also, if it is illegal, shall be taken to be an actus reus for the purpose of penal liability. No mere doing of an act, even if produces harmful consequences, even if they are prohibited by law, even if there is illegal omission, even if that is prohibited by law, unless punishment is provided for that, it will not fall within the scope of penal law. So, in all the cases, whether it is an act or it is illegal omission, all sequence of events must take place to complete it as a first requirement for penal liability. sequence of events which are required, that is, person must have done some act or must have done some illegal omission. That doing of an act or illegal omission is prohibited by law. It produces harmful consequences or is likely to produce harmful consequences, and these harmful consequences are the direct result, immediate result, proximate result of the actus reus of the accused. Then the last part of that punishment also is provided for that. If a punishment is not provided, then it will not fall within the scope of penal. So all these events must have taken place. So far the first requirement, that is actus reus, is concerned, then only it will amount to an offence punishable under the law. Now, further point which I want to discuss is that if there is a doubt with regard to either actus reus, with regard to either mens rea, then benefit of that shall be given to the accused. Because the prosecution is required to prove the guilt of the accused beyond all reasonable doubts. If doubt is there, benefit of that have to pass on to the accused. Now, the point which I was talking about last time, I now go to that. The point that was being talked about last time was that if due to some intervening reason, the connection between the actus reus of the accused and resultant harmful consequences is broken, has become doubtful, has become obscure, uncertain, then in that case, whether the liability of the accused still will continue to be there for causing those harmful consequences or not. Now, this part in fact relates to offences of murder. I just give an example before I start explaining that. That is, suppose A has inflicted serious injuries on B. When B was being shifted to hospital in an ambulance, that ambulance met with an accident. As a result of that, the man immediately dies. So the connection now has become uncertain, obscure. Whether the death is the result of the actus reus of the accused, or death is the result of accident which has taken place. Now, this intervening reason may be any, not necessarily that accident must have taken place. Intervening reason may be that a doctor is not available when they go to the hospital. Intervening reason may be that medicine is not available when he is taken to the hospital. Intervening reason is there is a long delay between the actus reus and the death of the deceased. For example, 10 days have gone, 15 days have gone. That may be an intervening reason which has made the connection uncertain or obscure. So in that situation, this question arises whether the liability of the accused will remain alive, whether still he shall be liable for murder, culpable homicide, or not. The answer to that is that where the actus reus of the accused is the operative cause, is the dominant cause in bringing about those consequences, that is the death in this case, then the liability of the accused will continue even though due to intervening reason the death has taken place earlier than required. Because had that intervening reason not taken place, it was possible that death might have taken place after some time. It may be by even half an hour or less than half an hour. It may be one day. Then in that case, liability will continue even though there is an intervening reason which has made the connection uncertain or obscure. Then this question arises: how to find out whether the actus reus of the accused is the operative cause, is the dominant reason in bringing about the death of the person? Because that is the question which the court has to take up in order to keep the liability of the person alive for causing the death. The answer to that is that can be found by the following principles. One principle is that suppose that intervening reason had not taken place, even then the same harmful consequences would have followed. Even then the death would have taken place, even though that intervening reason had not taken place. Then it can be taken that actus reus of the accused was the operative cause in bringing about that death of the deceased. This is one principle by which the court can find it out. Because in every case of culpable homicide or murder, it is the acceleration of death. Death is certain to come to everybody. So when that is brought earlier than in the normal course, then liability under criminal law is there for culpable homicide or for murder, as the case may be. So in that situation, one question which the court will look into that had the accident not taken place, even then the man would have died. Though he might have died after 1 hour, 2 hours, 3 hours, 1 day, 2 days, even though the doctor was available, even though the medicine was available, even then the man would have died, though he could have prolonged for some more time. So in that case, the liability of the person will continue to be there, and the person shall be liable for causing the death. It may amount to culpable homicide, it may amount to murder, as the case may be. Then next point, which again is to be considered along with this first point. The next point is, in addition to that, in such situations, court will also look into the nature of intervening reason and its likelihood in causing the death. What was the nature of the intervening reason? What kind of possibility was there by that intervening reason to cause the death? What was the nature of the actus reus of the accused? What the accused had done? What kind of injuries he has inflicted? Which part of the body is hit? What is the nature of those injuries? What is the weapon used? What is the age of the person? What is the medical opinion? All that has to be seen also. So the court will evaluate both nature of the intervening reason, its likelihood of causing the death, and nature of the actus reus which the accused has done. Then how much serious it was. After evaluating both, the court will determine whether in such situation the liability of the person will continue to be there for causing the death or not. Then next point in that situation is where the intervening reason is intentional because of the illegal act of some other person. Where it is natural, accident is natural, ambulance accident is natural, non-availability of doctor is natural, non-availability of medicine is natural, long delay may be natural. But where the intervening reason is intentional, illegal act of some other person, then in that case, the liability of the second person for causing the death will be there, not of the first. Even though the injuries inflicted by the first, suppose A has inflicted very serious injuries, B is not going to survive for half an hour, because vital part of the person has been affected. C comes, she cuts his throat, because C has some enmity with that man, so he cuts his throat, the person dies immediately. Now here, in this case, intervention by the third person is intentionally done by some other person, is attributed to the second person. He is liable for causing the death. He shall be liable for murder, not the first one. First one in that case shall be liable for attempt to commit murder, and the second one who has intentionally inflicted that injury shall be liable for murder or culpable homicide, as the case may be, depending upon the nature of the intervening reason which have taken place. This is the first lecture relating to actus reus itself. I just give you a summary of that again, because we are just started. I would like to be slow and repetitive, so that you are in a, because this is a very important area, so that you are in a position to note down every point which is being discussed. Again I repeat that unless some actus reus is attributed to the accused, no penal liability can be imposed. Second, that actus reus must produce harmful results or is likely to produce harmful results. Third point, that harmful results or harmful consequences or their likelihood is the direct result, immediate result, proximate result of the actus reus of the accused. That producing those harmful consequences or their likelihood is prohibited under the law. And last part, punishment is provided for that, because penal liability necessarily requires imposition of punishment upon the accused. Since lastly, just I conclude that there is a basic principle that a person is liable only for the harmful consequences which are directly resulting from his own act. He is not answerable for harmful consequences which are directly resulting from the actus reus of some other person. When that liability is to be imposed, that case will fall within the scope of vicarious liability. Then in that case, unless vicarious liability is invoked, no liability on that can be fixed. Why vicarious liability is there? What is the justification for that? All that we'll discuss when we'll specifically pass on to this area relating to vicarious liability. Some of the sections I had already mentioned. 34 is there, 114 is there, 149 is there, 376D is there, 96 is there. So some of the sections I have already mentioned where vicarious liability principle is provided. As and when vicarious liability is invoked, prosecution has to prove all the components, all the ingredients of that section by which vicarious liability is being pleaded. If he is being prosecuted with the application of section 34, all components of 34 must be present. What are those components? That we'll talk when we'll pass on to vicarious liability, when we will pass on to section 34. Or if it to be prosecuted under 114, all components of 114 are to be present. So all that sections relating to vicarious liability I'll be taking up when we pass on to that area after we conclude the first series of lectures, which I have told earlier is the most important part of that. And one more thing before again, that every act, every illegal omission, even though it produces harmful consequences which are prohibited by law, may not lead to penal liability. Because unless punishment is provided for that, unless it is designated as an offence, it will not invite penal liability. I just give an example for that. Under section 125 Criminal Procedure Code, duty is imposed upon a husband to maintain his wife, children. If he doesn't maintain, it is prohibited by law. But it is not made punishable. So in that case, even though procedure to be adopted is provided in CRPC for that, so that is a different area. Why is the procedure in CRPC in that case area is applied? That is a separate question. But in that case, since punishment is not there, proceeding will be continued as per requirement of section 124. It will not be designated as penal liability because it is not offence. Many such cases are there where act is prohibited by law, harmful consequences are produced by that, but still it is not taken as a criminal offence because punishment in that case is not provided. That is true to act also, that is true illegal omissions also, that is true to act providing furnishing grounds for civil action also. So this is the first part, first lecture, that unless there is actus reus, no penal liability can be imposed. Now we pass on to the second part. Second requirement is that a required mens rea must be there in order to hold a person liable under penal law. Because the different offences require a different level or different category of mens rea. I'll be making a brief introductory. Before I start discussing basic kinds of mens rea as provided in the penal code. Firstly, what is meant by mens rea? Mens rea means guilty mind, evilness of mind, attributable to the accused. Specifically, you will not find any section where it is provided that mens rea must be there. But that doesn't mean that mens rea is not required. Court will start with the presumption. As and when the case goes to the court, First question that comes before the court is whether actus reus is attributable to the accused or not. Whether all those events, sequences which are required for actus reus are there or not. Second thing which the court will look into is whether evilness of mind, guilty mind, mens rea is there in that case or not. The term mens rea sometimes is described as that it is a chameleon concept. Chameleon girgat कहते हैं जिन. That it is a chameleon concept. It changes its color, changes its nature as per the requirement of any offence. For some offences, dishonestly is required. For some offences, fraudulently is required. For some offences, reason to believe is required. Some offences, knowingly is required. Some offences, intentionally is required. So, which kind of guilty mind is required? That depends upon the contents of each offence. So that way we can say that though specifically it is not mentioned anywhere in the code, but mens rea or guilty mind is spread over in whole of the code in different shades, depending upon the nature of the offence. And as and when the case goes to the court, first question that the prosecution is required to answer, where is the guilty mind? As I have told in the beginning, that there is one exception also. That is offences of strict liability. Offences of strict liability. There, no guilty mind is required. But prosecution will have to prove that this is offence of strict liability. No single criteria is there. Many arguments are to be given by the prosecution to convince the court that this is offence of strict liability. So this aspect, how the prosecution proves whether any offence is of strict liability or not, that will take up as a separate topic later on. What are the arguments, what are the points which are to be brought before the court in order to convince the court that it is the offence of strict liability. So unless it falls in that strict liability criteria, otherwise courts always insist upon that mens rea has to be proved, that legislature cannot intend to create offence where mens rea is not required. If it is not required, the intention of the legislature must be proved by the prosecution that this is offence of such a nature where the legislature did not intend to include mens rea. So that part again we will talk later on. Now, I'll prefer to discuss separate categories of mens rea or guilty mind which are used in different sections. First in that case is intentional. Intention. Now, before I go ahead, I'll just prefer to clarify that intention is of two types. One, specific intention, particular intention. Other, general intention. Certain offences require general intention only, like kidnapping, a general intention is required. Offence of rape, a general intention is required. For some offences, particular intention is required, especially offences relating to property. Yeah, what is particular offence? Before I proceed further, what is a particular intention? What is the distinction between the two? Particular intention is that where a person is required to produce particular specified harmful consequences. Like in property offences, dishonestly. That the intention of the accused must be to cause wrongful loss, wrongful gain. That intention, particular intention, specific intention must be attributed to the accused. Prosecution must prove that. So, firstly, I'll deal with that. What is intentional act? What is intention? Now, firstly, it is relevant to all the sections. Any act done with intention, whether specific or particular, the person is always liable for that. Intention is not defined. There is no definition. Now, if you look at section 7, it says, where any term is defined, any concept is defined, only that meaning can be taken, no other meaning can be taken in that case. Since intention is not defined, there is no definition. How to find it out? Then the second alternative, that in those cases where definition is not there, person can look into other sources. Person can look into dictionary. Person can look into case law, judicial decisions. Person can look into any other law where it is defined. Person can look into the context in which the term is used. Person can look into the opinions of experts who have explained that concept. From these various sources, he will try to find out the appropriate meaning of that term. Since there is no definition, in brief, we can say that intention reflects the highest state of mind of the accused. That is when a person stimulates his mind, motivates his mind, directs his mind towards a particular goal which he intends to achieve. Then the mind gives direction to physical faculties to make efforts to achieve that goal, to devise means, to arrange material, to achieve that goal, to achieve that aim. And accordingly, the physical faculties do that, make efforts for that, to achieve that. That briefly can be described to be the intention of the person. But the question here comes, how to find out? How the court will find out? There is no instrument by which the court can peep into the mind of the accused. Because the incident before the court might have taken place 10 days earlier, 1 month earlier, 1 year earlier, 6 years earlier. So how the court will be able to find out what was the state of mind of the accused at the time of doing that act? Was it intentional? No material is there by which the court can look into the mind of the person. Then the answer is, court will try to find out the intention of the accused from all the facts and circumstances relating to the case. Those facts and circumstances shall be taken into account, and the court will accordingly come to a conclusion as to what was the state of mind of the person. Two persons may differ. I may take it intentional, you may not take it intentional. Because perception level, intellectual level of each person is different. So different person perceive the things in a different manner. But unless you determine the intention of the person, you can't impose penal liability. That the accused did it intentionally. So, as I have told, that in such situation, facts and circumstances of the case are to be taken into account. After evaluating them, court will reach at a conclusion as to what was the intention of the accused. I just give an example before we proceed. Suppose I am addressing a class. I have talked about some topic. Next day, I want to find out whether you were attentive in the class or not. I have no means by which I can peep into your mind that whether yesterday you were attentive in the class or not. So the only way out for me is to look into the facts and circumstances and then come to a conclusion. Still I may be wrong. I can look into your notebook. Have you noted the lecture? Whether it is the same lecture? I can ask questions. Are you in a position to answer? If there is a register, roll call register, I can look into that. On the basis of these facts and circumstances, I will conclude whether you were attentive in the class or not. As I have told that all the facts are to be taken into account. When I say all the facts, some facts are brought before the court and proved by the prosecution. Some facts are brought before the court and proved by the defense also. Court has to evaluate both. Those facts which are ascertained, which are brought, which are proved by the defense also, and facts which are proved by the prosecution also. After taking both into account, then only the court will decide whether you were attentive in the class or not. There is a possibility of the accused misleading the court. Like the example which I have just given. Suppose you have noted down the lecture from somebody else. You are intelligent enough to answer the questions. Somebody has spoken proxy for you, you are present in the register. The conclusion I will draw that you were very attentive in the class. In fact, you were not even present in the class. So that saying goes, Jo Jita, Wohi Sakandar. Whosoever succeeds in convincing the court by proving the facts favorable to him ultimately succeeds, resulting into either acquittal or conviction. Further, since as I have told, this is the most difficult area for the prosecution. Prosecution in most of the cases stumbles on this to prove the intention. To facilitate and in the interest of justice, courts have formulated two principles. Two maxims are formulated by the two maxims are designed by the courts. They are not written in any book. They are a part of the penal justice system. With the help of these two maxims, court will try to find out the state of mind of the person in any given case. The two maxims are, again I say, intention is applicable to all the offences. With the intention of causing death, with the intention of causing grievous hurt, with the intention of causing wrongful loss, with the intention of causing harm to the reputation, with the intention of... So that way, intention what you will find in all this action. So two maxims which are the creation of judicial pronouncements and which are taken into account by the courts to facilitate the determination of state of mind of the accused. First in that case is that every person is presumed to know the natural consequences of his or her own act. Every person is presumed to know the natural consequences of his or her own act. Presumption is created. Presumption is only with regard to natural consequences, not every consequence, only natural consequences. What are natural consequences? Natural consequences are those which any ordinary prudent person coming from the same kind of social background can perceive. That will be attributed to the accused. If you fire with a gun, hitting the man on the head, you ask this question to anybody, the man will die. Because a part of the body hit is very vital, nature of the weapon used is very dangerous. So in that case, if I snatch the book from hand of B, what is the natural consequence? He will lose it. I'll gain that. There is a wrongful loss, wrongful gain on my part, specific intention. So whatever will be the natural consequences resulting from the act, that will be attributed to the accused, whether actually he is aware of that or not. That is, it has to be taken from the point of view of ordinary prudent person, coming from the same kind of social background from which the accused comes. If he is urbanite, if he is a tribesman, educated person, uneducated, so whatever may be the nature of the accused, if the ordinary person from the same setup can perceive those consequences, they will be attributed to the accused also. This is the first presumption created under the law, that every person is presumed to know the natural consequences of his or her own act. Second maxim is that every person is presumed to intend the doing of that actus reus which he has done, which will produce those harmful consequences. Presumption, again, this I told you when we started also, that presumption is every actus reus is intentional. Every act is intentional. Whatever you do, you did it intentionally. So that is the second presumption, that whatever act you have done, you intended to do the same. Now I'll give the example again to clarify that. Suppose you hit B with a gun on the head. Presumption is that you intended him to hit him on the head. Presumption is that you knew the natural consequences. Both presumptions are there. First, natural consequences. Second, whatever act you have done, you intended to do the same. Both these presumptions are created which are against the accused. So apparently it appears that this is against the principles of fairness. On one hand, we say that every person is innocent unless proved guilty. That goes against that presumption. But here, both these presumptions are created, and accordingly the person has to be attributed with the intention on the basis of these two presumptions. So as I have told again, apparently it appears to be unfair. It goes against that principle that everybody is innocent unless found guilty. But there is a safety valve also. The safety valve is that accused shall be given the opportunity of rebutting these both presumptions. He can rebut these presumptions by leading evidence. He can rebut these presumptions by cross-examining the prosecution evidence. He can rebut these presumptions from the prosecution evidence itself. He can rebut that by the combination of all that, something by cross-examination, something by leading the evidence. So he can rebut that. If he rebuts that, he can wriggle out from liability. Now I again give the example. Suppose the earlier example I had given, a fire with a gun hits the man on the head, man dies. Presumption is he is liable for murder. He intended to hit the man on the head. He is aware of the natural consequences of that. That way he will be liable for murder. But he can lead evidence that no. When I was about to fire with a gun, I was aiming at the lower part of the body. When I was going to pull the trigger, somebody lifted the gun. This is how the man has been hit on the head. The man lifted the gun just to save him. Had he not lifted, the person would have been hit on the lower part of the body. Thus, it could have amounted to only grievous hurt. If he gives that evidence, and it is convincing also, he succeeds in convincing the court, then in that case, he can wriggle out from that liability. Similarly, in the second example, A snatches the notebook of B. Presumption is he is liable for theft. Both these principles are to be attributed. But suppose he leads the evidence that he has lost his notebook just now, then the title page of both is identical, that even the handwriting is similar, their contents are the same. Thus, it was because of mistake that I have taken that note. I never intended to take that. It was because of a mistake that I have taken that. If he succeeds in proving that, either by leading the evidence or by prosecution evidence from the cross-examination of that, then in that case, these two presumptions will not be applicable and he shall not be liable for theft. Thus, a kind of a safety valve is provided. With the help of that, accused can wriggle out from these presumptions. If he is unable to do that, then these two presumptions shall be applicable. Person in that case shall be attributed that he intended to do the same thing. He intended to cause the same consequences which he had actually caused. Thus, in that case, his penal liability shall always be there. So, I close here. We'll resume it tomorrow again. We'll continue with that.